Good afternoon, everybody, and welcome to another Red into Black webinar. We've done a few this year, and this is the last one for the year. I'm Stephen Michelle, as most of you will probably know, but we've got actually a big audience today because this is a very interesting and topical subject. And we've got Michael Buscema from Aptum, who has been heavily involved in a lot of the policy settings relating to director penalty notice and collection of debt, joining us today. Just a couple of housekeeping things. There's a chat button at the bottom of your screen. Please feel free to use it. Ask any questions that you might have. We'll leave the questions to the end. We'll let the presentation go through, and then at the end we'll come back and we'll actually answer all these questions for you. So anyway, thank you, Michael, for joining us today. Michael heads Aptum's tax practice and is responsible for managing tax controversy matters from audit, objection, and litigation, as well as complex ATO recovery matters. Michael has an extensive career in taxation, technical taxation policy, and complex dispute resolution. And for 11 years prior to joining Aptum, Michael worked for the ATO and the Commonwealth Treasury, holding a range of senior positions, including acting Assistant Commissioner of the ATO. And in recent years, Michael's been instrumental in steering the ATO's post-COVID-19 debt recovery strategy, giving him a unique insight into the ATO's latest approach. Thanks, Michael, for joining us today. We really appreciate it.
Thank you, Stephen, for having me here.
So, look, it'd be fair to say, as an insolvency practitioner, that certainly the SME insolvency market's been pretty busy and buoyant this year, and a lot of that's come off the back of the ATO issuing a lot of DPNs. So, why is the ATO actually issuing so many DPNs? In fact, how many do you believe have been issued, and why are they doing it?
So you're right, there have been a lot of DPNs issued, and there's been not only a lot more than that were issued during COVID, obviously, but there's also a lot more that were issued than pre-COVID. There's a couple of reasons for that. Firstly, if you look at the ATO's debt book problem, and I think there's been a fair bit of media out there at the moment around what that debt book problem is, you'll see that around 2/3 of it is activity statement debt, which is predominantly GST and pay-as-you-go withholding. And also superannuation is always a focus of the ATO. Now, those are the three tax types that are open to the ATO issuing a director penalty notice. So given the debt problem that they have, it is the most logical, firmer tool that they can use in order to try to recover it. That's part of the answer. The bigger part of the answer, though, is that because of the settings that were in place over COVID, the ATO took a backseat in collecting, and we saw a lot of businesses sort of rack up debt, perhaps quite rightly, so that they could trade through. And they've come out of COVID. Some entities were able to sort of clear that debt and move on successfully. Other entities needed to close. But you do have this group of entities who were viable but for this debt. And the ATO really noticed that the impact of accumulating debt without paying in real time is the most catastrophic thing, particularly in the SME market. And the whole policy rationale of the director penalty regime is to get directors to confront their debts earlier. So a big reason the ATO is using so many director penalty notices, not only to try to incentivize recovery or to incentivize entities to exit the system when they should, but to actually change the payment behavior of a lot of the time small businesses by enforcing their directors to look at that. And if you look at numbers, I believe in 23, 24 financial year, there were 26,000 director penalty notices issued in respect of 26,000 company debts. So that actually means there's a lot more actual director penalty notices out there in the community because each director can receive a director penalty notice. That was up from around 18,000 the year before that. I anticipate that number would stay fairly stable over sort of this year.
Yeah. So do you think that when do you think that the tax office will continue to issue a lot of director penalty notices, say for this financial year? Is that the expectation?
I would say so. The ATO still has a debt book problem, and they've still got what they call a payment culture problem. The payment culture being the deprioritization of particularly small businesses paying tax. So if a lot of people view the ATO having a lot of powers, and they do have a lot of powers, but they actually don't have too many recovery powers before they take it to court. They've really got the garnishee notice, the director penalty notice, and they've also got the ability to issue security bond demands. But the ATO doesn't like to send too many of them because they're not a bank. They don't want to take too many securities, right? So if you look at it through that prism, it's one of their main tools. You probably will still see the same number, but I dare say you will reach a point where you will start to see that the type of taxpayer receiving a director penalty notice to shift. There's obviously a backlog of people with aged debts that they're getting to, but the ATO is, through some of its messaging externally, is focusing on trying to address that accumulating debt. You might see director penalty notice being sent to directors of companies much earlier. So they might only have a BAS or two that's overdue, and bam, they get a director penalty notice. And that's not going to be expected, because often it's been viewed in history as a firm action for the ATO, but they're trying to change how the tool's used a little bit. So as advisors, whether accountants, insolvency practitioners, we're going to have, rather than taxpayers coming forward or directors coming forward and saying, oh, the company's a bit in the can at the moment, now I've got this DPN, I need to wrap it up. And we're like, oh, my company's got a bit of debt at the moment, I want to still trade on, I'm not too sure. You're going to have those discussions around, well, is now the point of insolvency, or is it too early? You might make a call on that, but then the implication is you don't then put the company into insolvency within those 21 days, and you can't then do it in the future. It's going to be a very difficult conversation for a lot of companies as those director penalty notices come through earlier.
And this is the bit about changing behaviour. Is that right?
Correct. Yeah, correct. And it's consistent with where the government is going. So we can see the payday super reforms slated to come in 2026. The idea of this real-time reporting and payment, there's opportunities for the ATO and its systems to leverage those mechanisms. We didn't see it really with single touch payroll, but there's an opportunity there for the ATO in the future where, if that's not coming through in real time, how can they incentivize that real time reporting and payment? And DPN, again, is one of those main tools.
Yeah, we're talking to directors every day about them receiving director penalty notices and large tax debts that are currently sitting there, and late lodgements and all those sorts of things that come with it. So with that in mind, so what are the warning signs? So we've got a lot of accountants in this webinar today participating, and a lot of them will have clients that will have tax related problems. What sort of warning signs should they look out for to sort of give them an indication that maybe their client potentially might be a target for a director penalty notice?
I think that the way that the landscape is changing, you almost have to look at it and through the lens of, my client is a company and they're about to lodge their BAS, or they've been late on their super and they're having to lodge an SGC statement. If they're not in a position to pay that immediately, you almost need to expect that a director penalty notice could be issued sort of within a month. I know that by itself is a change in the landscape. Historically, you would go through the various stages of the debt collection process, through nudge letters or texts to phone calls and then a director penalty notice. I imagine that sort of progression might still happen, but the shift is to pretty much have that happen in more real time. So in terms of a warning sign, it is that. There is sometimes an issue though with accountants. The accountants might be the accountant for the company or not the director. And there's that opportunity there. Well, maybe I have to have a conversation with the director. They're like, well, this might come through.
Yeah.
Most of the time, the ATO will still send a firmer action warning letter, which does what it says. It provides warning of a firmer action, which could be a director penalty notice. Again, those have historically come after they've sent some other less aggressive letters. Can expect those earlier. Again, we've got the same problem. If the accountant for the director is different to the accountant of the company, the director might not know about it because they're not receiving the firmer action warning letter. The company is. So accountants need to look out for that. Over the last few years, the ATO has been sending, typically in batches, director penalty awareness letters. So that was an attempt taken, given that directors didn't otherwise know sometimes a director penalty notice was coming until it came, because it's all the interactions with the company, they would send director penalty awareness letters. They might still doing that. It's not a requirement, and they were being tested. So if there's accountants out there that say, well, look out, you might receive an awareness letter before you receive one. Yeah, you might, but by no means is that a certainty. And I think that that might not be a thing in the future as well. So I think it's paying attention to the receipt of the awareness letters. If a company has any pay-as-you-go withholding or GST debt, but particularly any SGC debt, then, and you haven't got a director penalty notice, there needs to be discussions with an accountant, but also an insolvency practitioner to, one, see if there's options, provided the director penalty is not locked down before you get a director penalty notice, or come to some payment arrangement with the ATO, which would prevent them from taking a recovery action. But yeah, the reason I say super in particular is I said that around 2/3 of the debt book is pay-as-you-go withholding or SGC. Around 2 billion of the 52 odd billion of collectible debt is SGC, but around, or I think it was around 8,000 of those 26,000 DPNs issued last year were in respect of SGC. So the proportion is much higher for SGC.
Hmm. And quite a few of the accountants, I'm sure, would have clients that come to them and, they may have prepared a BAS or got PAYG debt or even super debt. And the client will say to them, well, look, we don't want you to lodge that at the moment because we don't want to let the ATO know that we've got a debt that's sitting there because we can't pay it.
Mm-hmm.
What would you say to those accountants as a response to that? I mean, for example, estimates and director penalty notices. How does that sort of work?
Yeah. So there's a couple elements of this that taxpayer directors and accountants particularly need to be aware of. On your estimates point, so the ATO, if there's no lodgements for any of those three taxes, withholding, GST, SGC, the ATO can make an estimate of those amounts. Typically, they do that more in pay-as-you-go withholding situations. They would be more inclined to just issue a default assessment if it's SGC and GST, but they are capable of doing estimates as a quicker way to do that. And then if the company doesn't do anything with respect to either varying those estimates, then the ATO can issue a director penalty notice to a director that operates in the exact same way that it would be if it was an actual liability. So there is always the risk, particularly for withholding, that if they don't lodge the BAS, the ATO will just put forward an estimate, and they will do that often based on just what's previously been reported. A big thing that we're seeing, though, is that a lot of director penalty notices are being locked down. So what that basically means is where a GST or a pay-as-you-go withholding liability is lodged by the company after 3 months, or if it's SGC, if that's lodged after the due date, then the corresponding director penalty liability is what's called lockdown under the law. It's not a discretion thing by the commissioner. And that basically means that putting the company into some form of insolvency doesn't actually remit the penalty for the company. And here at Aptum, we've seen many cases where people come forward and they say, I had a director penalty notice, I got advice, I put the company into a VA or an SBR, and the company debt's all dealt with. Why is the ATO still chasing this debt? And you can look at a director penalty notice and it will tell you, it has columns that says amounts reported within 3 months, amounts reported out of 3 months. And if it's out of 3 months or outside of the due date for SGC, those are locked down, and none of those actions would remove a director's liability. And accountants need to be careful of that in providing advice, as do restructuring practitioners or administrators, etc. And when it comes to the original point of, well, maybe don't lodge, yeah, that's not going to generate a debt. But if it does end up coming back, or the ATO issues an estimate or a default assessment and you're outside those time limits, you don't have the option as a director to utilize the insolvency processes, and you can find yourself on the hook for your personal assets, even if you've done something to rectify the company situation.
Yeah. So really, one of the key points is that they need to, companies need to lodge their returns on time. Otherwise,
Yes.
directors may very well be on the hook for a lot.
Yeah.
Director penalty notice.
Particularly for super, just because it doesn't even have that 3 months that were reformed specifically to circumvent that. And I imagine there's a few people dialed into this call who have seen situations where the ATO might send a director penalty notice after a company has already been liquidated and deregistered. And that's a very difficult situation for a director to find themselves in, and it can only happen for lockdown DPNs.
Yeah. So it's probably so for those that don't know, it might be just to go very briefly, you've gone into lockdown DPN, but maybe what a non-lockdown DPN is as well.
Yeah, sure. So basically a standard DPN or is where if amounts of GST withholding were reported either on time or within 3 months is the test, and superannuation guarantee charge statements were lodged by the due date, then those penalties aren't locked down, which means that either before you've received the director penalty notice, because you're actually liable for director penalties before the ATO sends you the director penalty notice. It's just a precursor for them to recover. But at any stage before you receive it, or once from the date that the ATO sends the notice, you have 21 days to remit the penalty, which wipes it for the director by either paying it, obviously, but you also have the options with standard DPNs to appoint a restructuring practitioner, to appoint an administrator, or commence the winding up of the company. Causing the company to take those steps would remit the penalty in full where it stands, which is why those lodgement dates are so important in those situations.
Yeah. So let's say you've got a director, they've got a director penalty notice. What should they do upon receiving that? Because the penalty notices, as I understand it, they go to the director's registered address as per the ASIC register. Is that correct?
Correct.
Yeah.
So by law, the ATO needs to send it there. And by law, if you haven't updated your ASIC address, so that's not a defense to a DPN. We see it all the time. Oh, I hadn't updated my ASIC records, or I asked someone to update my ASIC records and they didn't. I never got it. So unfortunately, that doesn't get you out of a DPN. And also another thing that people sometimes don't realize is the 21 days starts from the date that the commissioner puts it in the post, which with current Australia Post timelines, you actually don't have 21 days. You sometimes have just a bit over 2 weeks. So if you've received a director penalty notice, the first thing to do is get advice, whether that's your accountant or a lawyer or otherwise, to clarify what your options are. And it will explain it in the director penalty notice, what your options are. You'll be able to tell whether it's standard, which means you can utilize one of those options to put the company under, or it's locked down. And based on that, you can then potentially speak to an insolvency practitioner around the options to put the company into an insolvency process. Because if those 21 days expire and you don't take those steps, the options become far more limited for a director. Once the 21 days elapse, the only options really to deal with the debt are if you have a defense. And the defenses are strictly listed out in the law, and they're very narrow. You basically need to prove that for illness or some other good reason, you never took part in the management of the company. So not just a period of time, for all the time, or you took all reasonable steps to cause the company to comply with their obligations. And the courts have held a very high threshold for that. There are also some defenses for GST and super if you took a reasonable position with respect to the super or GST laws. If you're in those sort of situations, you're outside the 21 days, then maybe you can get advice around prospects of running a defense. But all in all, I think the prospects of defenses getting up with the ATO are fairly low, I would say. Well, definitely much less than 50. It's probably closer to 10 to 20%. So again, it comes back to if you get it within 21 days, it is the most important, one of the most important notices that you need to act on if you get from the ATO, and that 21 days is vital. Do not delay in speaking to your accountant. Don't assume that your accountant will get it because the accountant doesn't receive it. I think accountants can view it in their communication history on online services for agents or in their practice mail, but unless you're regularly checking that every day for a client, you're not going to see it, right? So I think the clients need to know that the accountant's not going to spring up for their agent. Accountants need to go directly to, clients need to go directly to their accountant. And if there's an option, insolvency practitioner is the way to go.
Yeah, and it's interesting because the notices, I think, sometimes for the lay director are difficult to understand in many respects. And yes, I think maybe some directors are on the, just don't actually know what it really is. But I suppose for those accountants that know that their clients have got tax debts that are outstanding, it's probably something to warn their client about.
Yeah,
They might need to deal with it.
that's definitely where we're going and what the ATO has been trying to sort of communicate, particularly to agents, is that there's a strange scenario that plays out with director penalty notices. Quite rightly, directors will be running their business through a company. They'll have an agent responsible for managing the tax affairs of the company. And to a lot of directors, they just think, my agent's dealing with everything. And that's often a reasonable assumption to make. But because of that rule around having to send the director penalty notice directly to the director, directors will receive it. And to your point, one, it is difficult to understand. It's a legal notice and it's complicated. But also, there's an assumption that, well, if I know about it, presumably they're talking to my accountant about it. And they might have contacted the accountant through trying to deal with the company. But if that accountant's different or the accountant's got other things on, there can be a gap and that you can't take that, that assumption at face value. So we have had situations where clients have asked, well, what's my recourse as against the agent here? And you have to work through what those steps are. And there is an obligation, obviously, that primarily rests with the director. But it is something for agents to pay attention to. Because if I'm having conversations with clients around lodging and lodging on time, what the implication of this debt arising is, what they need to be aware of in managing their obligations, there is definitely scope within those interactions for agents to have conversations around what the practical impact of director penalty notices is, because they are technical and there's a lot of rules around them. But at a very simple level, if you don't pay those amounts, you can expect one in the not too distant future.
We've had a couple of different scenarios that sort of come up from time to time. I got a call the other day from a company that I'm the liquidator of, and it was a director or a former director that had received a director penalty notice, but he had resigned as a director, a number of years ago, but still had picked up a director penalty notice in relation to it, and they were querying why that might be the case.
Mm-hmm.
Can you comment on that?
Yeah. So the way that it works is that it is the directors who were, there's two parts. If you were a director at the time that the obligation arose, then even if you're no longer a director, you're capable of receiving director penalty notices. So former directors are caught up. Obviously, current directors are caught up, but also new directors can be caught up. So upon becoming a new director, you have a grace period of 30 days to do those steps I said earlier around the remission options to sort of bring the company to an end as to not rack up the debts. But if you go past that, then you're on the hook personally for director penalty liabilities as well. So there's no discrimination when it comes to the director penalty regime. Former, current, and future directors can all be caught up by it. And that then often leads to a discussion, particularly for former directors, around I had some form of indemnity or arrangement with the co-directors around this. That might be the case. And there is provision in the tax law that says if you have to pay a director penalty, then you can seek an indemnity either from the company or other directors. Unfortunately, that's a civil matter and it does not limit your liability to the ATO. In fact, it operates such that you actually have to pay the ATO and separately work it out with the others. So there is that. Likewise, we also hear from people saying, well, I was a former director, but I never actually, I was a director on paper, but I was on the tools and my mate was doing the finance stuff. Also doesn't work that way. If you're listed as a director with ASIC, the obligations fall on you as director, regardless of whether you actively took a role in that or not as well.
Because sometimes we will see a situation where a person resigns as a director, and they may resign very shortly before the company goes into liquidation, and another director comes on board. The new director, let's say they don't avail themselves within the 30 days to do something relating to the company and in particular its tax affairs. How far back can the tax office go with a director penalty notice on that person?
The ATO doesn't have, well, there's no statute of limitations on the recovery of taxes. So they would be treated like any other director, in which case, like any other director, from as long as the regime's been around for, and I'll speak just briefly on that shortly. Obviously, director penalties only apply from when the regime came in, but technically you can receive a DPN going back that far. Have I seen many DPNs issued 20 years ago or 12 years ago for super? No. But I have seen them issued for sort of 5 years ago. I mean, it's not unheard of. So again, I think the ATO will move towards more sort of fresher debts. You're not really going to change the behavior of a taxpayer for something that happened 5 years ago. You're going to change the taxpayer's behavior by focusing on how they deal with their current liabilities, but it still remains a risk.
So a director, though, the director can't argue, well, I was only a director from this particular date, a short period of time ago. It can go back all the way back, basically, for as far as the debt was incurred.
Yeah, depending on circumstances, it is possible.
Yeah, okay. Yeah, so they really need to do something. And then, of course, the old director is only on the hook for the period of time that they were a director. Is that right?
Yes. So once you resign, you're not then liable to future ones for when you are no longer a director.
And I take it that when they resign, it's the lodgements with ASIC again that are the important things.
Yes. So the ATO relies almost exclusively on the ASIC records. And if you receive a director penalty notice and you say you're not a director, then you need to overcome what is basically a presumption that you are because of the ASIC records, which I have seen overcome previously, but it is difficult.
So with the debt, so let's say you've got multiple directors, and each of them gets a director penalty notice. Let's say the company does fail, goes into liquidation. Um, the the tax office can only get paid once, can't it?
Yes.
Yeah.
So the way that the law works is that the ATO can simultaneously or concurrently chase everyone, company included. But the debts aren't joint and several, but they're parallel. So basically what that means is, so for the example I said earlier, the company might go under, but if it's locked down, it doesn't reduce the company because they're parallel. But if amounts are paid towards the underlying liability by either the company or one director, it proportionally reduces the liability of the other. So in that situation, the company will be just hypothetical liquidation, and the liquidator is going to pay out a dividend that's going to see, I don't know, $20,000 go to the ATO. Separately, one director is going to chip in 50,000, and the overall debt was 100,000. Those payments would go through, and both the company will be different because the debts will be caught up in the liquidation, but the directors would have the benefit of the 50,000 from the one director and the 10,000 coming from the distribution.
Hmm. Okay. Now, we're getting close to the end. Are there any words of wisdom or recommendation to in particular the accountants that we've got here about what they need to watch out for, particularly maybe over the next 12 months or so?
Yeah, I think you're going to see director penalty notices being sent sooner, I imagine. I mean, there is always the political sensitivity of the ATO going too hard in an election year, but it's on the cards. That means that clients are going to need to know what the impact of a director penalty notice is, because if they don't do anything within those 21 days, they can't get out of them in the future without paying. So I think familiarizing yourself on the impact of them, and if you're the agent of a company, ensuring that you're looking out for those warning signs, whether it's the unpaid BAS on time or the SGC statements on time, or the company's got a firm action warning letter, telling the client, hey, from any point this point onwards, you could receive a director penalty notice. This is what would happen if you do. I think that's the biggest takeaway. I think there is also familiarizing yourself with what the difference between a standard and lockdown director penalty notice is. I have seen a few matters now where directors have been told, if you put the company into a VA, you don't have to worry about this director penalty notice. And lo and behold, they do that and the debt is still there. Understanding that and speaking to an insolvency practitioner around what the sort of the implications of that would be is important. And if you're not sure if it's lockdown or standard, you can either, the ATO would probably be able to tell you, but you can also seek advice as well on that too. I think they're the two main points, but particularly for super, you're going to start to see them earlier, I think.
Yeah. Maybe just as a final point, you've got, let's say a director has an expired director penalty notice. What can the ATO do to actually then recover that amount?
Yeah. So once the 21 days elapses in the DPN, then the debt becomes like any other tax debt. So the recovery options will range. You'll probably get, director might get letters and phone calls, or it could go to an external collection agency. Those are things that typically happen quite early on. If those break down, or you don't voluntarily approach the ATO to pay that amount, then you could see a garnishee notice. Garnishee notices have historically mostly been sent to banks, but we're seeing more and more go to sort of employers or merchant facilities for a percentage. If you're at the point of receiving a garnishee, most of the time garnishees don't recover the debt in full. They're used as an engagement tool. But you can expect that the ATO will commence legal proceedings. It is interesting, though, to see how that's going to play out, because the ATO has, while it picked up legal recovery, it plateaus because it's a very resource intensive purpose. So the ATO jumped up in 2023 for legal recovery proceedings, but then it's probably not going to go, it's not really any higher than what it was pre-COVID, and it hasn't really changed too much from then. So the more and more director penalty notices they issue, the more and more people will be capable of going to court, but the ATO doesn't have the ability to take them all to court. So accountants are going to have the situation where the clients have got a debt there, 21 days has elapsed, it might be garnishee action, and it actually swirls a little bit, which you could say, well, that's good news. The ATO is not going to bankrupt my client because they don't have the resources. But it is an enormous mental strain on taxpayers as well, just having these debts sitting over their heads. So if you find yourself in those sort of situations, again, I think the best step is if you wait for the ATO, it's probably not going to be a good outcome, but you also might just be waiting a very long time to have that burden, in which case, again, your options are probably best to speak to an insolvency practitioner.
Yeah, that's good advice. All right, we've got a few questions, and I am conscious of the time, so we'll get through these relatively quickly. The first question is, I've met with a director who's never received a DPN, but a DPN debt of the company appeared on their personal account. That's the only way they knew. Any comment about this?
I would put good money on ASIC details not being updated by the director. 9 times out of 10, if not almost 10, that is what happens. That said, though, advisors should always look at a director penalty notice and check for errors. So it's very easy to get an ASIC extract. If those addresses don't match, DPN's probably invalid and the whole thing goes away. Of course, the ATO can issue another one, but potentially if the 21 days is expired and it's invalidated, you then have more time to look at a insolvency process. So do check that, but I would anticipate that would be why.
And I assume that that's when someone comes to you and they've got an expired DPN, that's probably one of the very first things that you would do.
Yes, 100%.
Indeed. Second question, how long would a director who has left the company be held liable for old debt that has been issued at DPN? If that makes sense.
Well, that could mean one of two things. If you're asking how long after they leave the company before a director is off the hook from receiving a DPN, I hate to tell you, there's probably no time limit. I mean, the odds of it being sent get lower and lower, but it never disappears. As for if you have already been sent one, how long does the ATO have to recover it from you after you're no longer a director? Again, there is no time limit on it. There used to be some time limit for indirect taxes if they hadn't notified it of you within sort of 4 years. That provision didn't apply to DPNs. It's gone anyway. There is no limits on recovery. So it's just a risk-based call for the ATO. I would say that for super, they'd be looking back further. Yeah, I wouldn't be holding on to it in the hope that, well, after a period of time, it will disappear.
I did go to a seminar that the ATO ran some time ago where the question about having DPNs issued, post a VA or a DOCA or a liquid
It's a bugbear of
actually
mine.
raised, yes. And there's not a huge amount of them, but there are a few. And the comment that was made was there's a bit of data matching that goes on, in particular with individuals' tax returns. And the example was rental income, which tends to suggest that they might have a rental property, which then tends to suggest that they might have the ability to pay a lockdown DPN.
Yeah. So one thing to note on that is when I said before there's a lot more DPNs issued, a lot of people assume that they're automated, AI, whatever. DPNs aren't. Every DPN is considered by a person. What they consider, though, the process gets a bit streamlined. The HO has obviously got recourse to a lot of data. So in a situation where you've just described post-VA, it would seem a little unfair. They will look at the taxpayer's capacity to pay, and that's informed by the data that they get, for example, through reporting, through returns and stuff like that as well. So the odds of that occurring might be higher for someone where there's information to the tax office that would suggest that they have capacity to pay.
Next question. Do we have a view on restructuring plans and the ATO view of them, as they seem to be the largest creditor in the ones I see?
So
The small business restructures.
yeah. So when I left the ATO, which was only a few months ago, the ATO was accepting roughly 90% of SBR proposals that were put up that were obviously valid proposals, which is a very high percentage. So in terms of the ATO's view on them, they're largely open to them. The ATO is caught in a position where it can't reach commercial outcomes with taxpayers. You could go to them and say, look, I'm either going to go bankrupt or I can offer you X cents in the dollar, and there's no ability for the ATO to be able to accept it. So the ATO actually encourages people to look at options like small business restructuring because it gives them an ability to agree to a commercial proposal that they don't have unilaterally. So they're actually pretty open to it. Is there, given the sharp increase, is there scope that the ATO could change their mind on that as people really readily make use of the SBRs? Maybe that will change in time. I wouldn't be surprised if that changes after a period of time. But for the current time, the ATO can't collect their way out of their debt problem. They need companies who are sort of insolvent technically to utilize insolvency processes. So for the most part, they would encourage people to use them if appropriate.
Yes, and look, that's our experience is the same. Probably over 90% of the ones that we've done have been accepted, and yeah, they've been a pretty good thing to save a lot of businesses. Next question is, how much does a D&O insurance policy protect against a DPN? I'm not sure if you can answer that one, but
I actually don't know. I mean, I was in the AHO for some time. I was in their debt area for many years in their strategic recovery area. I never saw the argument get put forward. It probably happened outside the ATO context though, so I wouldn't know.
I would have thought that with D&O policies, there's generally some form of insolvency restriction that's actually in them. So you'd want to look at the wording of the policy, I would have thought.
Yeah.
Next question is, so if I'm a new director, I can be responsible for past debts before I was a director.
Yes, and a lot of directors don't know, and a lot of accountants don't know in advising clients around, or financial advising clients around what they should do with joining companies. There is an enormous due diligence risk in becoming a director of an existing company that needs to be watched out for.
Yeah, it's pretty important. What is the position if a DPN is issued and then the ATO accepts a repayment plan, negotiate with the company? Is the debt still on the director's personal?
Yeah, so this is a good one because a lot of people get confused. So short answer is the debt stays on the director penalties account, on the director's account. So the law basically prohibits the ATO from taking steps to recover the director penalty if there is a payment plan on foot, and that applies in practice to both the company and the directors. However, that's just a procedural prohibition. The debt still stays there. So if the payment plan defaults, often payment plans default because of overdue lodgements and stuff like that, then bam, the ATO can recover. Now, the most troublesome way that this arises is when directors first get a director penalty notice and they've got the 21 days because they have a choice of what they do. And they might choose at that point, well, I'm going to enter into a payment plan because I did the wrong thing. I owe this tax. I want to pay it. And we see a lot of people with good intentions try to enter an arrangement within those 21 days, but they're actively making a choice for standard DPNs to not utilize insolvency options. The risk with that is if for whatever reason circumstances change and they cannot meet the terms of that payment plan, they've lost that 21-day window to use an insolvency process, and the director penalty is still there, less any amounts are paid on the payment plan. So it's something that needs to be considered carefully. It does not remove the director penalty notices. It just acts to pause the ATO's ability to recover them from you while the payment plan's in effect.
Yeah, thank you. And just as a final question, okay, what is the ATO's attitude to debit loans in SBRs and liquidations?
They don't look at them overly favorably. I mean, I mean, you probably answer this better than I will.
Yes, look, I probably can. Look, a lot of the SBRs that we've done have got either Div 7A loan accounts or debit loan accounts, and some have been large and some have been not so large. And in a liquidation, well, liquidator doesn't have discretion, so liquidator will look to try and recover the loan account that's actually sitting there. In an SBR, we've had quite a lot that have been successful, in that 90% range. And generally where there's a large amount and there's very, very poor tax compliance, that's where I think you've got a risk that it might not be accepted.
My view was that I think that's one of the risk factors that they're more alert to. And then if you couple that with, as you said, tax compliance, they're the 10% on that don't get up.
Yep, I agree. Well, Michael, look, thank you very much for attending today.
Thank you for having me.
It's a fascinating area. It's one that's very topical. It's one that most accountants and in particular insolvency practitioners are dealing with all the time. So I really thank you for taking the time and sharing your knowledge with us. Obviously, if you've got clients that need assistance from either a legal perspective, Aptum's a great place to go to get that advice. And from an insolvency perspective, please consider us. Thank you once again. Thanks everybody for attending today. This is the last Red and Black for the year. So I wish everybody a very happy and safe holiday season, and we'll see you next year.
Thank you, Stephen. Thank you, everyone.